Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross.Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don, thanks for coming on the show here.
Thank you, Jim. Thanks for having me.
Our monthly update today, but before we get into that, let's talk about yourself. Give us a little background about yourself.
I'm a local attorney. I've been an attorney since 1982. Tax degree. I focus in real estate law. I've been the attorney for Downing Fry for about 30 years. I own part of the company, own Ross Title and Escrow. We've done 20 to 30,000 closings. I don't keep exact count. Own law firm. I have a staff of people that for the most part have been with me from anywhere from 30 years to 5 years, and 4 of them are family. So it's by design. We want people who know each other, like each other, and communicate better, so that we're able to do a better job, hopefully.
They certainly do, and they do with our customers.
Oh.
So, I mean, I can vouch for that too.
Thank you, Jim.
But today, I wanted to do a show today because now we're getting into summer here, but we're going to go into fall and developer contracts and our local contracts. I'd like to talk about the difference between the two because there's a huge difference between the two, and a lot of people go in and they go to a developer or they go to a community. They don't really get representation by a local agent, and there's a lot of clauses in that contract that can be something that they don't understand, right?
Absolutely, and it really not just 2 contracts. We're using developer contracts as a genre, but within that genre, you know, each developer has their own type of developer contract.
True.
So it's not like I can write the definitive article on what's in each and every developer contract. They all have little tweaks. They all have little time bombs that you have to look out for, otherwise you get burned. So my thought was, well, I'll outline some of the things that I've seen over the years that I specifically look for. Because not only are there, if you have 20 developers, you have 20 different developer contracts. They're literally different.
Exactly, they are. But the
There's
things that we're going to go over are common things, right?
They're common themes. One, they're very thick. So when you get something that's very thick, most people don't know. Well, they're not going to read the whole thing. It's just your brain will fry and evaporate
Right.
if you read the whole thing, because it's written in legalese, which might as well be a Latin or Greek. Some of it's plain, some of it's not. Some of it are terms of art, legal terms with a special meaning that isn't necessarily a common sense meaning. So you've got this very thick document. The customer does not know what's important and what's not. So you got the legalese. Then you don't know, well, this is boilerplate regulated by the statutes, and this is custom by the developer, so you don't know how to read out the differences between the two, and you don't know what to focus on. The developer contracts, all different. There's no inspection process. You're not checking for mold. You're not checking for radon. You're not running permit searches. The normal things that we would do with NABOR. So if you have a particular health issue of some sort, you're not going to be able to run a mold test to see whether or not your reduced lung capacity is going to be impaired by just plain old allergenic mold. It doesn't have to be toxic.
So we're talking about doing these inspections prior to closing, but
yes,
you can do anything you want after.
You don't have any of that with a developer contract. In fact, they have clauses in them that say you can't come on the job site without their permission, because they have insurance rules. They don't want people wandering around and stepping on a nail or falling into a ditch. So you need permission, and it has to be negotiated.
You have to be accompanied usually by a superintendent.
Yes, they for insurance purposes, for legal purposes, they don't want people just wandering around while people are putting on a roof.
Right.
God forbid they get hurt. And so they're very conscientious about that. The closing costs, a client calls and what are my closing costs? I don't know. I mean, because they're all different. I have to read it and see. But some of the things they do is they'll play games with the documentary stamp taxes on the deed, which is $7 per thousand, and the title insurance. Sometimes they'll flip them where the developer does the title insurance, provides it. It costs a little bit less than the dock stamps, and then they put the dock stamp obligation on the purchaser. Sometimes they do that. Sometimes they charge a % of the purchase price and provide both the title insurance and the dock stamps on the deed to the buyer. Sometimes they'll give financial incentives to the buyer if they use the developer's mortgage company and the developer's title company. And that may or may not be good depending upon how long you intend to own the property. If you're going to own it for a long time, it might be terrible. If you're going to own it forever, it might be good. So it's hard to say. So you got to look at what the costs are. The walkthrough process we've talked about previously. Some allow you to have a third-party inspector to check the property for you. Some don't. And people, it's a counterintuitive concept, having a brand new home inspected. Why do I need to have that done? Well, you have all these different people doing different parts of the construction, and whether they hooked everything up needs to be verified. It's not the contractor supervises, but sometimes things just aren't hooked up correctly.
Sometimes they get missed because even I've heard people say, the county is inspected it, the builder, and blah, 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 but it's not necessarily true. They could miss a spot here. I mean, we try and have an inspection done if possible prior to closing. I think it's hard. There's more things wrong with a newer home, I believe, than even a resale home that somebody's living in, because they find out, if something's not working, they fix it.
Well, the left hand sometimes doesn't know what the right hand is doing.
Right.
My dad was a builder, you were a builder, so I know that unless there's complete communication between the plumber and the sheetrock guy and the framer and the finished carpenter, it's not going to be integrated correctly. They're going to miss something. There'll be a gap somewhere, and the inspector can help verify that. Plus, that's what they're trained to do. I mean, realtors aren't trained to do it. Most lay people aren't trained to do it. So if you're spending a significant amount of money on a house, spend a few $100s and have somebody inspect it. It just seems prudent to me. People tend to walk into developer contracts on their own. They're not presented to them by a realtor unless it's the realtor for the developer. Huge mistake. These people are hired because they're so darn likable. They are realtors, but they work for the developer. They do not work for you, the buyer. So when you walk in and they're really nice and they seem friendly, well, that's their job. I mean,
that's right.
Otherwise, they wouldn't be hired. So, people fail to put down Jim York or whoever they work with.
Or they fail to ask.
They don't even ask.
Sometimes they just think they advertise in the newspaper, and I'm not throwing developers under the bus,
Sure.
but, come out and look at our models, but, then there's a registration form and they fill it out. And sometimes they could put our name on or no agent's name on there, and there might be in fine print, if the agent doesn't bring you in, we can't represent you afterwards. And just like you said, they're paid by the developer. They're, not
it's a job.
It's a job. So, when we take people in there, not to get sidetracked here, but if we're going that far to do a contract, I would ask, I want to get the contract beforehand, rather than signing it the day and whatever day we go to sign it, and they really aren't prepared to look at, and have you maybe look at the contract and give us the high points of the contract that maybe things they should be aware of.
No, they're literally
that's right.
That thick.
Yep.
And who's going to read that on a Sunday afternoon?
Right, and they're, like you said, they're written by attorneys. They're worded that maybe it's hard to understand.
Legal terms.
Right.
So the walkthrough process, the people from different states, they don't understand. Some you can have the inspector, you want the inspector. People don't necessarily understand that you don't get the escrow money at closing if something is not totally finished. You don't get to delay the closing. In fact, if you don't close, most contracts have some sort of penalty provision at the developer's discretion.
They do,
Usually the developer has the right to terminate the contract, keep all your money, and then they can either agree to sell it to you and fine you $250 a day. It's usually around that, $150 to $250, or just keep your money.
That's right.
So they don't know that's in there. Some contracts have a penalty in there if you resell the property within a year.
Yeah.
They want to develop communities that are, the people live there. They don't want it to be all investors. They want the community to thrive and
spend money,
have
right.
people move in with children who will
Right.
send them to school, and so that ensures the longevity of the community. If it's just investors, one good recession can knock that community out. So I've seen penalties for resale within a certain time period. Some of the clauses are just stunning. I mean, they have the ability to reposition a house on a lot. And they could flip it around so you're facing the other guy's pool instead of facing away from the pool and having privacy.
Yep.
They literally have that right in most of them. They have the right to change materials if a certain product isn't available. If they ran out of that particular refrigerator, they can get another one of similar quality, whatever that means. So that's not something you're going to see in a standard, say, NABOR contract. They can change prices. They usually have disclaimers in there that they have the right to change the prices on any of the other units in the development. And I always go back to the recession where, you know, there was a certain development in Lely Estates where they knocked the price from 300 to about 160 or 180, I forget what it was. And the people who bought before that at the full price were threatening to sue the developer, so they throw that in there now, that they have the right to change the prices if we have another recession. They'll refer to the woods and so forth and say, they may not be there forever. You know, we disclaim any responsibility if there's going to be a shopping center or something commercial there, because that goes into the duty to disclose latent material defects, materials that we've talked about in the past. So there's a lot of stuff in there, and I've just touched on some of them.
Yeah, and I think you did a good job. I think it just gives our viewers some idea what's going on with developer contracts, and then we're going to take a little short break, and then we're going to talk about local contracts, so people, if they listen to the show, they can see the developer and see the comparison, the difference between local contracts. And we'll be right back in 1 minute. We're going to have a little commercial about the York Group and Donald Ross. We'll be right back.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross.Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Don, well, we covered the developer contracts. Let's talk about our board contracts, our local board contracts, and the difference, because there is a big difference in it. So.
Well, the board contracts, the basic contract's 10 pages, and it's taught. It's the same. You don't have 30 of them. Like if you have 30 developers, you have 30 developer contracts. So you got one version. It's usually revised every couple of years unless there's a statute, a significant statute that changed. So you're taught it. You know what the closing costs are. I know where to find the seller expenses, from memory. I know what's at the bottom of page 6. You know paragraph 4 is the financing contingency. You know how time's calculated. So it's something you can study and learn and discuss with your customers on the telephone, no problem.
Right.
The other beauty of it is more middle of the road. They actually make an effort. It's not always successful, but I think they make an honest effort to make it middle of the road. It doesn't heavily favor one side like the developer contract does. What I use as an example for that is the closing costs in Collier are allocated a little differently than, say, Lee. The seller pays the documentary stamps on the deed, and the buyer pays for title insurance.
Right.
And the reason they did it that way is to try to be fair and try to split the main closing costs between the seller and the buyer. There was an attempt at being fair. So, that's why that's that way. I know exactly where it is in the contract. I know what it is if the property is located in another county. I don't have to go running to see, is this the Lennar contract, is this a stock, is this a Pulte, and see how they're all different. There are a whole bunch of addenda and amendments to the NABOR, the Naples Board of Realtors contract, that give the realtor and the customer added flexibility when they have an unusual situation. And when the seller needs to stay a day or two after closing, we have a form for that. If the buyer has to move in early, we have a form for that. We have a seller disclosures form, and we get to study it, and we know what's in it that could hurt the seller if they sign it.
That's right.
Or the buyer
discloses everything that they know of that's a defective.
But we have 70-odd forms
exactly.
that we have the ability to pull out of the book and use when we have a customer sitting in front of us with an unusual situation. Say, oh, we got a form for that. I mean, a lot of questions I get from people are answered with, oh, we have a form for that.
Right.
Let's look at the form. This is simpler. You might change it a little bit, but it is generally something that we can at least start with, in which developer contracts don't have.
That's right.
The inspection process and sharp relief, and again, in all fairness to developers, the home isn't built yet,
right.
So there's nothing to inspect. But we have a very definite inspection process. We got our 15 days and 5 days to ask for repairs or a credit, and then the seller has 10 days to respond, and the buyer has 5 days to cancel if something is said, no, we won't repair that if it's a defective item. So we have a definite procedure. There's a certain flexibility in what's working condition and what's cosmetic.
That's right.
It has to be because of all the different factual scenarios that occur in life.
During an inspection.
It's got to be an elastic document to a certain degree, or it'll just break. So we've got that. The financing clause is much better than the financing clauses we see in developer contracts. Developer contracts, again, deal with properties that aren't built yet. It's almost impossible to lock in a rate for a place that isn't going to be ready to close for 9 to 12 months.
Right.
So you don't know exactly what you're going to get with the financing clause in most developer contracts, whereas the NABOR financing clause, it gives the buyer much more certainty as to what it's subject to this interest rate, this term, whether it's conventional or something else. We have little blocks you can check off, and they know what they're getting supposedly before they waive the financing contingency if they so choose to do so. Right. So I like that. The NABOR contracts are signable. Mm-hmm. Some developer contracts are not. Some developer contracts will actually. They could take your money, your deposit, if you even advertise the property, if you put it in MLS before you close on it. And I've had that threat made to me.
Right.
And I won't name who the developer is, but there's probably 2 that have that in there. So you look for that. Is it okay? If it's 1 year before the thing is going to be built, and your client wants to list it with you, even though they haven't closed on it, legally they can list it even though they haven't closed, unless the contract says that you're going to forfeit your deposit if you do that. So they don't want the buyers who haven't closed competing with their new product.
True.
Is what's the story. So I look for that. With the NABOR contract, you can assign it, so you get all these people who, if the closing was in 6 months and they wanted to flip the property, they don't actually have to close. You can sell the contract,
right.
which I've done many times.
Sure.
So that makes that a heck of a lot easier. And the addenda we talked about, it covers all the different situations, and I think that's pretty much it.
It's a lot simpler contract, and it's more straightforward, and it's much more, and it's middle of the road. Right.
It's not perfect. None of them are. The FAR bar isn't perfect. The NABOR isn't perfect. People debate the pros and cons of, say, permits in the NABOR contract now.
Right.
I think they're trying to limit it to maybe a certain time period now because there's so many open permits out there.
Right.
People go back and forth on whether mold should be in the NABOR contract. It's not in the FAR bar contract,
Right.
the statewide contract. So you can have an honest difference of opinion, but at least we know what it is.
It's true. Well, Don, I appreciate you coming on the show
Oh,
again.
thanks for having me, Jim.
You do every month for our monthly update, but this I think is very important for our viewers, and hopefully they listen to the whole show, and hopefully we learn something from it, and we'll see you next week.
Thank
you.
you.